course here, because this is an important one, especially for the recording session. And I want to make sure we get this one recorded. And as a matter of fact, Lavoria or Benny, can you maybe send me the file? Because I want to make this into an actual class to go into the archives, because I definitely want folks to start doing. Oh, you know what? Matter of fact, no, don't worry about it. Don't worry about that. I'm gonna record this again on my own, and then we're gonna upload that to the archive. So don't worry about recording this. I'm gonna record this on my own, so we can upload it to the archives. Let me share the screen. Estate planning. Let's see here. Estate planning is one of the most important sessions that we have, but it's one of the least talked about sessions that we have. And more, no, excuse me, let me rephrase that. Estate planning is always talked about in everybody's lives, but most of the time it's talked about too late. And most of the time we talk about estate planning is when it's too late. We talk about estate planning after individuals have passed away, and then we want to then address the needs of the estate. So the purpose of this class today is we're going to talk about these things before it's too late. And we want to talk about these things in advance. As a matter of fact, I'm going to be purchasing and sending some books to the office for individuals to have some homework assignments. So hopefully you'll be able to talk about this with your friends, talk about this with your family. So at the conclusion of this, you'll be able to open up a discussion to actually put an estate plan in your household. And so this is why I've tried as best I can to make sure we can promote this particular class for other individuals to come on and jump in. Estate planning is important. Let's talk about a story about Terri Schiavo. Terri Schiavo was a young lady, and at 26 years old, she had a heart attack. This is February 25th, 1990. Those who, like myself back then, I was actually in I was in middle school. I was in 8th grade, and had heard about the story, and I saw it on the news, but didn't really follow it. But later on in later years, when I started to research what it was, this story of Terri Schiavo really shows that, one, everyone needs an estate plan. An estate plan is not just about how much money you have. It's also about other items such as a living will, healthcare proxy, which we're going to talk about. So hopefully you can take some notes for this one, especially take some notes, and then go home to your family, to your friends, your family, your mothers, your daughters, your sons, your daughter, and have a discussion to say, these are some things we need to put in place to make sure that our estate plan and our households are taken care of. So she had a heart attack. The diagnosis was changed she had massive brain damage, 1991, persistent vegetative state. And then for 7 years, she had her feeding tube in there. 7 years. So finally, her husband comes along and says, hey, I want to remove the feeding tube. It's just, for those who sadly know about this story and have experienced this with loved ones, when you remove that feeding tube, usually the death comes not too long after that. So the husband wanted to get the feeding tube removed. And again, we don't know how much money she had. A lot of folks mistakenly believe that a estate plan is all about money. We didn't know about money, but this is an estate planning issue. 3 years later, so now after 10 years, finally, court sides with the husband and the feeding tube was removed. The family comes back in and says, no, I want to make sure I want to get the feeding tube put back in. 2001, the feeding tube was reinserted. Then 2005, go back again. It's like a ping pong match at this point. Feeding tube gets removed. Husband wins again. 13 days later, Terri Schiavo passes away. Okay. So now we're looking at an entire 14 years worth of arguing. And in that 14 years, we have 14 appeals, numerous motion, petitions, and hearings, 5 suits in federal district court. We had everyone's jumping around. So the state legislator jumped in there. Jeb Bush jumped in. U.S. Congress jumped in. George Bush, president, he weighed in. 4 denials of certiorari. Need to get my legal experts to help me learn how to pronounce that word. From the Supreme Court. Supreme Court says, no, we're not going to deal with that. High visibility, you got the right pro-life people on one side, right to die folks on the other side, books being published on the family. Everybody's speaking about Terri Schiavo. But the thing about it is, with a good estate plan, Terri Schiavo could have spoke for herself. She could have made her own decision with just a living will. A living will, a written statement detailing a person's desires regarding their medical treatment in circumstances where they are no longer able to express informed consent, especially in an advance directive. Okay, this is a living will. So if she would have wrote down what she really wanted before, then all of this back and forth from the governor and the president, all that stuff would have never happened. The living will would have been her words when she couldn't speak of what she wants to have happen to her. So the husband, the first one was trying to her husband, and then everybody else started jumping. The husband and the family, then everybody up to the president was chiming in on what to do with her life. The estate plan is about you making decisions for yourself, empowering you to make your own decisions, to understand exactly how you want to be treated if you're not able to make those decisions on your own. It's the preparation of tasks that serve to manage an individual's assets based on the event of their incapacitation or death. How do you want things to go down if you're unable to speak for yourself or you pass away? It gives you a voice when you're voiceless. Okay? It gives you a voice when you're voiceless. And it's the legal way of giving you a voice when you're voiceless. There's 5 elements of an estate plan. There's 5 elements of an estate plan. You have a will, a living will, healthcare proxy, durable springing financial power of attorney, and a living trust. Now, the will, a written or typed statement that declares a person's intent of the asset distribution at his or her death. There's 2 ways individuals can pass away. That's with a will or without a will. You got testate versus intestate. With a will means I have a will, it's testate. Without a will, intestate. Now, in both ways, you have to go through probate. But if you don't have a will, that if you pass away intestate, the probate process is even longer because now you don't have any words written down. Usually with a will, it goes through testate anyway because through probate anyway, because it has to they have to make sure that it's the most current version of the will, that the will was not written under duress, that you were in the sound mind when you wrote that will. So all these things have to be, the will is not being challenged. Are there any challenges to what it was stated in the will? All these things. So even testate has a process that you have to go through when you're talking about a will. Intestate without a will, then it's just a free-for-all. That's where we have a lot of individuals who go around trying to challenge for different properties, all those type of things. So we got to make sure that you have a will. A probate is a legal process in which the will is reviewed to determine whether it's valid or authentic. It also refers to the general administering of a deceased person's will or the estate of a deceased person without a will. So again, with or without a will, testate or intestate, you still have to go through probate. And so that being the case, you want to make sure you have your will. You want to get someone to help you devise that will. Items that usurp the will. There are certain things when you say usurp the will, meaning that it goes around the will, that where it becomes even more priority than the will, where like a 401k beneficiary. That's why I want to make sure all your 401k is up to date. We just did a class last week. 401k, you want to make sure that's up to date because that usurps the will. For those individuals that are stated as beneficiaries on your 401k, those assets will go to them without checking the will. Okay, your IRA beneficiaries, your life insurance proceeds usurps the will. Payable upon death, you go to your bank, say, hey, I'd like to have a payable upon death. So the items that are in my checking account, savings account, God forbid something happens to me, goes to these beneficiaries. That usurp all of these needs to usurp the will at least every 5 years. More than that, especially if you have any major life-changing incidents like marriage, birth, divorce, death of a spouse, those type of things. I've met a lot of folks that have dealt with their spouse passing, their previous spouse passing away. I actually met someone where she was a beneficiary, but she was an ex, and her spouse's new wife was saying that, hey, I want those assets in the 401k because the husband didn't update the beneficiary, and it was a total mistake. And in that particular case, it ended amicably because it was understood that, yeah, the husband would have wanted his new wife to get the access to the beneficiary because she had gone on and she was remarried and all that stuff. So she said, you know what? He just forgot to update the paperwork. So you want to make sure that all your paperwork is up to date. All right. So pop quiz. Pop quiz. Let's see if we got pop quiz for Lewis and Corey. We're doing these pop quizzes now where individuals can earn points. If you earn a point, then we're giving away a $50 gift certificate for those individuals at the end of the 11 weeks who have the most points. $50 first place, 25 second place, third place, $12.50. All right, so pop quiz. And the first one to write the answer in the chat will get a point. All right. So pop quiz. A, B, or C. This is a question about probate. What is probate? What is probate? Is it A, a type of tax? B, the legal process of validating a will? Or C, a retirement account? So what is probate? A type of tax. So B, Corey says B. Is there anyone that wants to say, he was the first one, is there anyone that wants to say something different besides B, in case Corey is not correct? What is probate? A type of tax. B, a legal process of validating a will. C, a retirement account. And the answer is B. That is correct. Good stuff. So Corey gets a point. I keep all my points in my phone here. Good stuff. 10 questions about your will. Will you do it yourself or use a software program? The advantages are, there are advantages of both. Software program obviously is going to be cheaper, but sometimes if you have a will, like I know there's a few folks on this call, on this Zoom call right now, that need to go ahead and make sure that they got their estate plans in order, if you know what I'm talking about. Okay, make sure your deeds are all together. Make sure your assets are together, especially if you have a business and you have assets in that business. who will be the beneficiary of those assets and what's going to happen to those assets, especially if you've paid off a few things. Hint, hint. You want to make sure that your family is all notified of exactly what happens. God forbid something happens to you. But will you do it yourself or use a software program? Well, if you do it, well, again, having an attorney that can actually walk you through all the loopholes, especially if your estate is large enough. If you have multiple pieces of property, your estate's large enough, and you might have issues in terms of trust issues with family. That might be a case where you definitely should have an attorney who's qualified to check it out. Who are your beneficiaries? You update your beneficiaries at least every 5 years or whenever a major life change incident happens. Who's the executor of your will? That's a major piece. Who do you trust to make sure they can execute all the things that's going on that you wish in case you're pass away? Who will be the guardian for your kids? This is a major thing. If you have children that are of younger children that can't take ownership of those assets as of yet, who's going to be the guardian? Do you trust that person to make sure that they can manage those assets for your children until they are of age to receive those assets? Are you specific enough with your assets? Run into this a lot. A lot of times individuals might say things like, I'm actually filming right now from my father's house. And if he says all the artwork, it goes, but which artwork? Okay, he has a lot of artwork here. So what's going to happen? Is it going to be that? Where does that piece go? Or let's say you have 3 cars. Each person gets a car. And I'm thinking about a real scenario. Person passed away, they had 3 cars, 3 children. Each person gets a car. They didn't state which car. Okay? The children got into a huge argument over the car, which one is going to receive that particular car. And they wanted that car. Well, that car is worth more than that car. And I want this one. And that car, I was the first one to drive that car. And I drove that car. It was a real big kerfuffle because they just couldn't they couldn't decide on who got which car. They were not specific. Did you have a conversation with your heirs? How many times do we have these wills created, but we don't talk about them? And that's where the biggest problem with probate comes in. I'm telling you right now, attorneys love where family members don't speak to their heirs. Why? Because that's an automatic indicator that we're going to have a huge amount of fees in probate court, because if you don't talk to your heirs and get everybody on the same page, that's more prone to have a lot of argument, a lot of challenging of the will. So have conversations with the heirs. And that's the point of trying to get other folks to jump on this call. We got to talk about this stuff with our people. We got to start talking about this stuff. Would you like to say more? Sometimes individuals don't write enough in their will. Did you get it signed by witnesses? Where can you store your will? Do you have a safety deposit box? Do you have a P.O. box? Someplace safe where individuals have access to it. Make sure the executor knows where that storage place is, and they know how to go about accessing it, God forbid something happens to you. Did you review and update your will? Make sure you're doing that on a regular basis. The living will, this is what Terri Schiavo needed to have. A written statement detailing a person's desires regarding their medical treatment and circumstances in which they are no longer able to express informed consent, especially an advance directive. Again, the living will states, this is what I want to have happen to me. God forbid I'm in a position where I can't do this for myself. If I can't speak for myself, remember, the living will gives the voice to the voiceless. It makes sure you're able to speak and have a conversation. Living will tips: hire an attorney or do it yourself. I actually recommend hiring an attorney. There's different places like Legal Aid that can get you a good, a low cost or maybe even a free person to give an attorney over, especially over your living will. Research your state's requirements. Check out what they do in Illinois. Every state has different requirements, different things in which they have. Determine your end of life care. There was a discussion when Barack Obama was writing the Affordable Care Act, where they started to talk a lot about in that the proposed legislation, they talked about they call them death panels. Well, that was a scare tactic to say, hey, we're talking. Well, actually, death panels are actually very good things, because a death panel is nothing more than you having a conversation with your doctor, like, God, hey, doc, if I'm not able to make these decisions on my own, if I'm uh, like Terri Schiavo, here's what I want to have happen. So end of life, how do you want to be treated? Do you want them to resuscitate you, pull the plug, or do not resuscitate? Whatever it is, you want that to be known. Tell your healthcare proxy and family, keep advance directive in a safe place. Make copies. The healthcare proxy, now the living will outlines what you want to have happen to you in case, God forbid, you're not able to do those things on your own. But the healthcare proxy is the person that appoints the agent to carry out the wishes in your living will. So expresses your wishes to make healthcare decisions for yourself if you're unable to speak for yourself. So healthcare proxy, very important document to have. Should get one. Your healthcare proxy, the agent should be 18 years or older, responsible to carry out the wishes. Choose a person you trust to make these critical decisions. My mother's not my healthcare proxy. All right. I mean, I'll be honest with, if I personal decision for me, I don't want to have to live with tubes all up in my nose. That's not a life I want to live. That's just for me. Okay. So my healthcare proxy is not my mom, because my mom, I know, will be under the guise that she's going to fight for her son. God forbid something happens to me, I get in an accident. If I got all these tubes and stuff up my nose, I don't want to live like that. So my healthcare proxy knows, hey, if it's about trying to live that way, or if I'm in a vegetative state and I'm in a coma, don't go ahead, and I don't want to live like that. My mom would not feel the same. So I could not have my mom as the agent in my healthcare proxy. It's a personal decision that you have to really think about. Choose a person comfortable with the role. My person is my doctor. Okay, my doctor, I have a physician, and they are, and I talked to my physician. I said, Dr. Tonetti, when God forbid something happens to me, I want you to be the one to execute he said, absolutely. And he does it for a lot of his patients. Many times, he said, man, I do that for a lot of my patients. And he said, I've never had to be, he said he's thankful, because it's a good problem to have. He's never had to be the one to actually be the one to say, pull the plug. It has never happened to him. But he said, I hope I never have to use this power. And I said, I hope so too, Doc. I don't want you to use this power either. Trust me, I don't. But he's my healthcare proxy in case that. It can be changed at any time. It can be changed at any time. And, as I go back and forth between, I'm actually thinking about changing it, because my primary physician care is still in Detroit, even though I live in Jersey City. So I go back home enough where I can get checked out. But I'm starting to think maybe I should go ahead and get someone locally. But I've talked to Dr. Teddy about that. He says it's easy to be done. The contact information's on there, so he can do it. But I was thinking maybe I should get someone closer. I know Dr. Tonetti, we talked about that. He said that he has no problem with making that. They're going to call him, God forbid something happens. But these are the type of conversations that we have to start having with our doctors and with our family. Like, my family knows. My mom didn't like to hear that news, because it's a very morbid type news. But these conversations we have to have. They're hard conversations, but we have to have these conversations. Durable springing financial power of attorney. This is a power of attorney that springs into action. It springs into action, sometimes called a conditional power of attorney, a legal document that is a type of durable power of attorney that only comes into effect. This is a key line here. It only comes into effect after certain conditions are met, typically when the principal becomes disabled or mentally incompetent. So the power of attorney is a very powerful document. And the power of attorney can do a lot of things. Filing, it can access financial accounts, file your taxes, investment decisions, collect debts, manage property, apply for public benefits. So a power of attorney can do a lot of things. You don't want to have someone having this power over you just walking around willy-nilly. You don't want to have somebody walking around having that power over you unless a court deems them to be able to have to make decisions because that you are incompetent. So right now, if you have a regular, matter of fact, if you want to talk to your elderly, your family, your grandparents, if they give power of attorney to someone, this is where a lot of the scamming comes into place because a family member or a friend comes over, or as older people are getting younger, if that makes sense, right? Older individuals are getting younger, meaning like 70 is not the 70 as it used to be. 70 years old, 80 is not the 80 as it used to be. My father just got home. I'm staying in Detroit this week. Just got home from playing golf. He's out. 80 is not the same as it used to be, folks. So that being the case, a lot of older folks are dating younger. We've got 70, 80-year-old women dating 40, 50-year-old men. And sometimes, you know where I'm going with this, a lot of scams come in that place. I had a good friend, her aunt got scammed by someone I'm actually going to do a couple of videos on that. Got scammed by someone, but a big scam is a younger person getting with an older person and getting them to make them to be power of attorney. And this happens a lot. This happens a lot. So guard your parents, guard your friends, your family. They get that power of attorney, and then here you have all the things that this person can do. Okay, they can take money from your account, and then boom, they're off, and they're off in Aruba somewhere, and they clean out all your account. So what it can't do, the power of attorney cannot change a will, break fiduciary duty, make decisions on behalf of the principal after death, or change or transfer to the power of attorney to someone else. You have to make that decision on your own. But the durable springing financial power of attorney springs into action when a court of law. Now, the disadvantage is that it takes a little bit longer. You have to have a court of law to say, yes, we're going to appoint this person to be that individual, that the person, appoint this person to be the attorney, in fact, to execute that durable, and you are not mentally competent to make your own decisions. So the question is, who are you going to appoint? You can have more than one agent. You're going to name alternates. How many originals should be executed? Where are you going to store them at? Where you store your documents is a very important question you need to ask. Do any of your financial institutions you deal with have their own power of attorney forms? All right, so these are just basic questions. Then we got pop quiz. Pop quiz. Pop quiz. Multiple choice question. What does the term estate refer to? What does the term estate refer to? A, only real estate properties. B, all of the assets and liabilities you own at the time of your death. Or C, a specific bank account. What does the term estate refer to? So Lavoria says B. She's the first one to answer. Is there anyone else who wants to state a different answer besides B that feels that Lavoria is wrong? What does the term estate refer to? Only real estate properties. B, all the assets and liabilities you own at the time of your death. C, a specific bank account. Anyone want to say A or C in case Lavoria is wrong? And Lavoria is correct. Good stuff. You get another point. Writing it down here. Good stuff there. Living trust. Let's talk about this. also called an inter vivos or revocable trust. And estate planning too. Now, I will say in terms of trust, for those who have properties, they might want to think about getting a trust. Just saying, could be something to think about, right? For those who have assets, you might want to think about a trust. An estate planning tool increasingly used by individuals of all income brackets as a way to pass on property while generally avoiding costs and delays associated with probate. The trust avoids probate. The will goes through probate. Remember, testate or intestate. Okay. Pop quiz question. Pop quiz question. I'm giving. Intestate means true or false? Pop quiz question. Intestate means passing away with a will. True or false? Intestate means passing away with a will. True or false? Pop quiz. This is for a point. See if y'all are paying attention. Intestate means passing away with a will. True or false? Lavoria says false. Does anybody else say true? Lavoria's racking up the points. Good stuff. Intestate means passing away without a will. Intestate. But good stuff. So you got that's 3 points for you now, Lavoria. So the living trust does not have to go to probate. A trust is basically a contract with is a contract with yourself. Okay, so you are the original trustee. You appoint a successor trustee. Okay, but you are also the grantor. As the original trustee, you're the grantor. You grant the rights as a trustee. Well, basically, you have a contract with yourself. You're alive. You're in a sound mind. You write up this trust. And then in that trust, you write out all your property, all your assets, everything, and how things want to be treated in case you pass away. You then grant, God forbid something happened to you, all the rights of the control to a successor trustee. That successor trustee's job is to carry out the wishes as designed in that trust. So you have a contract with yourself. You pass away, the rights go to the next person. And that person reads your trust, your wishes, and then disseminates property in the way that's outlined in that trust. There's no probate in that. The trust, a little bit more pricey. I think I wrote the pros and cons. Pros is avoids probate, avoids guardianship or conservatorship. It keeps things private. So if you have a trust, it avoids that. Cons, a little bit more costly. You still should have a will and an estate plan, okay? But the heirs have longer to contest a trust. My mom has a trust where this is going to sound morbid, but her husband passed away, I believe it's 3 years in August. But we helped her put the trust together, and we're sure that if God forbid something happened to her, that her husband's that passed away, children might want to contest that trust, because and I'm only explaining that it sounds like too much information, but these are the type of conversations we need to have with our families, folks. So when he passed away, he left all of his assets to my mom, his wife. His children are like, yo, what happened? So my mom was like, his little something broke off, a little something, say here from the estate. They didn't have a good relationship. It is what it is. But my mom now has a trust. Form that trust I would say about 4 years ago. About 4 years ago. So we have another year for them to contest that trust. God forbid something happens to her. Okay. Passed away 3 years ago, but the trust was formed 4 years ago. 5 years you'll have to contest the trust. But those are the type of conversations we have to have. If you have stuff written down on paper, it becomes a lot easier. And it can be a little. Now it was harder to write that trust, and we went back and forth with the attorney a lot in terms of the legal language to make sure that the trust was actually sound and up to date. And we went back and forth, all the assets and the properties. And then we have to update that trust because as my mom is now thinking about moving into a condo, we're going to have to update the assets in the trust and all those types of things, right? So make a list of all your assets, find paperwork for all your assets, choose your beneficiaries, choose a successor trustee. You must choose a person who you trust. You must choose a person who you trust. Choose a guardian for your minor children. Cannot designate a guardian for your minor children through a living trust, but you can include this information in what they call a pour over will. A pour over will can also is the vehicle that individuals use to designate a guardian in this component. Very important to make sure all your stuff is together. Alternatives to living trust: arrange for the most valuable assets to go to heirs outside of probate. And now we've talked to you, a few folks on this call about this. Property owned jointly with rights of survivorship goes directly to the joint owner upon death. That usurps all of that. Pensions, retirement accounts, life insurance policies automatically transfer to the beneficiary. That's why it's important to keep your stuff up to date. Payable upon death, same as with the will. Some states allow a car beneficiary. If you own a vehicle, hint, hint, somebody might have paid off a vehicle or two. How's that asset being held? Is that God forbid something happened to you? Where's that asset going to go? Make sure the right person is designated to get that vehicle, because that asset is still worth. You don't want the state to control that truck or car or whatever it may be. Some states allow transfer on death for real estate. Probate has been streamlined. The probate process is a lot more streamlined than what it once was. Selecting an estate planner, a valuable website that I want you to write down here: National Association of Estate Planners and Councils. I've found many estate planners. I found them in Illinois, Michigan, New York, New Jersey, California, Georgia, Florida. Where else? Because I get a lot of questions about this. And so anytime somebody asks a question, Louisiana just did that one not too long ago. And anytime somebody hits me up on my hotline asking for an estate planner, this is where I go: National Association of Estate Planners and Councils. I go and then I refer them to that individual, and here's a good state. Or if they're worried about, from a financial perspective, not being able to afford it, then Legal Aid Society helps with a lot of things as well. Ask your financial advisor for a referral. Ask your accountant for a referral. Consult with other attorneys in your network. Contact your state or local bar association. Check advertisements. Contact your local probate court. Tips for estate planner. These are important tips. I want you to screenshot these or get a copy of this for later on. Don't limit your search by geography. Sometimes they might live on a different side of the state, but still can be pretty good. Be aware of unaccredited internet directories. Does the attorney focus on estate planning? Sometimes attorneys don't focus on estate planning. So you want someone that focuses on estate planning. Beware of bar association referral hotlines. Sometimes individuals just join these, or they're not necessarily qualified because they want to be in the referral network. Just because somebody is in a hotline doesn't mean that they're qualified to run your estate. Slogans and popularity don't mean attorneys are fit for you. That's easy. What school do they attend? Where do they go to school? Do they have malpractice insurance? Ask that question. Do they belong to any professional associations? Again, I like NAEPC because they actually have a good screening process of the types of attorneys that are actually qualified to do some good work. Clear disclosure of clear disclosure of fee ranges prior to making any appointment. Never make. I'll add this to it. Never make a decision to go with that attorney after the first meeting. Make sure you talk to referrals. Make sure you know exactly how much they charge. And so, let me see here. So there you go. That's estate planning. If anybody has anybody have any questions about any of that, I know that's a whole lot of information. I'm gonna send this deck right after this meeting is over to all of you. If you have any, this is an important topic, and I'm gonna send this deck, and I want you to take this deck and read it over with your family. Read it over with your family. Read it over with your friends. Uh, let's really get into the point of trying to break. Let's break over this whole taboo of not having an estate plan. Okay. So with that, I think I'm gonna have to do the poll and quizzes. Now, I'm gonna share this poll with you. Just fill it out as quickly as possible, I guess, because it shut off on a few people last time. But I'm gonna share this poll right now. If you can share it, if you can fill it out as quickly as possible, and it's gonna go right. I'm just launching right now. If you can fill that out as quickly as possible before it shuts down, because it shut down the last time. Now I didn't push any buttons. If you all could shut down. And Tavares, you missed a good conversation, brother. You missed a good chat, but definitely want to love to have you sit down and let's talk about this estate plan. I'm going to send this deck over to you. If you all could fill this out, do you all see this? I know it's a little long. It's long, I think. But a couple people say that it's long. See, one person, Corey had to dip. If you all could, I guess
So I was able to finish it, but some of the questions don't really apply to financial literacy.
oh, let me see. I haven't seen it. Let me read them. Cohort numbers 3, new things I learned today, ways I can use, questions still have. Oh yeah, 7. 7 is not a financial literacy question. 8. Yeah. Well, I think
I
8.
mean, I still rush through it a little bit, but I'm like, it really doesn't apply to us.
se- 7 is not. 8. You have to stretch to do that one. Uh, mm, yeah. I mean, I'm assuming that this was a poll that they've created for all virtual pieces, so I can understand it. You don't want the perfect to be the enemy of the good, so they get a general consensus of the type of education and capturing I think the comments are one of the most. I think from what Tina was telling me that the comments and the commentary is one of the most important things that they want from it. So I think, is that everybody? Is there anybody still filling it out? All right. Well, it's 12:35. If anybody's still filling it out, speak now, forever hold your peace. Or 11:35 your time. Thank you all for joining the session. We'll be back next Wednesday, and I'll be calling you all to keep these office hours going. Talk to you all soon.
Bye.
Have a good one now.